motion for leave to appeal of Esther Lungu and 7 others versus the government of the Republic of Zambia, case number 096565.
My lady and Mr. Kwabe.
My pleasure, my lords, my lady, for the respondent with my learned friend Mtsweni.
Before we proceed, let's deal with the issue of the question of time allocation. We've received heads of arguments in this letter, and we intend allocating you about 20 minutes.
Yes, sir.
And about another 10 minutes for the reply, and we also allocate 20 minutes to your colleague.
As you please. I have my arguments which have been received, but there are articles that are not generally available that we've relied upon. So perhaps if I should just hand those up. There are 2 articles, scholarly articles by Magda Slabet and another one by Price. So if I could hand those up.
Should be uploaded, Mr. Mukaito.
Should be uploaded inside.
We're at paperless point on the mail.
All right, yes. Well, I understand the legacy of Justice Mlambo lives on. But if any of the justices require hard copies, yes. I don't know how many trees I've destroyed. And then, it's 3 bundles of authorities, so it's not 3 separate. And then this is the last one.
We've been handed up the same document. I've only got 2 sheets. Oh, hang on. Yeah.
Yes. You may proceed and take me right to it.
Yes. Thank you, my lord. The court knows that we ask for leave to appeal on the basis of reasonable prospects, and alternatively on the basis that the matter is of sufficient public importance that a judgment by the Supreme Court of Appeal is warranted. The court also knows the latest authorities on this point, that on that second leg of the test, which is the judgment of Southern African Litigation Center, what really the SCA says there is that it doesn't matter what the view of the court is on reasonable prospects. If the case is sufficiently important, it may grant leave to appeal on that basis alone, even if it believes that the prospects are not good. But this case stands on a different footing. We say that the prospects are strong. In relation to prospects, there are really 2 issues I want to argue. The first one is on the question of the choice of law and where that takes us. And then the second is the application of the South African Constitution to the dispute, and whether it should have been applied, and if it had been applied, what the outcome could have been. So on the question of lex loci, which is the choice of law dispute, now it seems that if we are correct in the way we understand the judgment, that the judgment separates between burial rights and the contract. On the burial rights, it applies the Kaunda judgment. And then on the contract, it applies Endumeni, which is a South African authority. So it seems that the contract itself was decided according to South African law. And then the burial rights, it's unclear whether the court regarded the burial rights as a species of contract or as a species of public law. But on burial rights, Kaunda applies, and then on contract, Endumeni applies. And that already gives us a difficulty, because we have 2 systems of law in the same judgment that are applicable. And when you actually look at our learned friends' heads of argument that we filed this morning, they also seem to understand the judgment in the same way that we do. Because what they say in relation to the contract is that the judgment itself says our law applies. And you will see that in the heads of argument, paragraph 24, and then you will see there is a reference specifically to Endumeni on the under paragraph, I want to see, paragraph 16. So it seems both parties understand the judgment similarly, that burial rights is Zambian law, the contract is South African law. Let me start then with the contract, what South African law is on contract, because that's what we've tried to spend a little bit of time exposing in our written argument. Now, when it comes to a corpse, a dead body in South Africa, the law follows the Roman Dutch system. In fact, when we research this, it comes all the way from the Roman law. It's affirmed by Foot as well as Hugo de Groot in their exposition of the law. They both say that a corpse is outside the realm of contract. No one can contract about a corpse. A contract over a corpse is ipso facto contra bonus mores, something that cannot be contracted upon. Foot, as well as Hugo de Groot, have been affirmed in several judgments that we have traced. So if I could take the court to our judgments, our heads of argument. So we deal with this from paragraph 32 of the heads of argument. So we say that our common law, which is now given effect to by the Constitution, the position was that Roman Dutch law proscribed the contract over a corpse because the human body and its part were classified as res extra commercium, things outside the sphere, the commercial sphere, in this case the contractual sphere. A corpse was not regarded as a thing that could be owned and thus capable of being transacted over by contracting parties. Indeed, according to Professor Price, and that's the article that was published in the South African Law Journal, which we've attached there, it's called Legal Rights and Duties in Regard to Dead Bodies, Postmortems, and Dissections. The deceased executor and or their spouse and heirs had a restricted legal right of possession, which conferred on them the right to bury the body in accordance with the wishes of the deceased. Now,
In terms of the will, it says.
Yes. In the absence of the will, you will then see what happens when there is no will. When there is no will, the judgments then start from paragraph 33.1. Sage versus Scutts, 1971, it's a Transvaal decision, where the portion we've cited says matters affecting the disposal of a corpse are really subject to litigation, with the result that there is very little modern guidance on the subject as a whole. But applying general legal principles, it would seem reasonably clear that the primary duty of the executor, or failing him, the surviving spouse, child, parent, or other near relative, is to dispose of them in accordance with the terms of the will, provided that this is not impossible, too expensive for the executor to bear, or unlawful. It has been stated that in English law, the executor is not bound to obey the terms of the will in this particular regard. Even if this proposition is correct for English law, it does not follow that it is correct for Roman Dutch law. Grotius, that's the other name for Hugo de Groot, specifically says that a will, besides disposing of the deceased property, may deal with other matters such as guardianship of his children and directions as to his burial. It is taken for granted that the heir must carry out the terms of the will as far as possible. It therefore follows that in our law, directions in the will as to the disposal of the body must, if possible and lawful, be followed. Now, what then happens when there is no will? Firstly, if you have a will, it must be followed if possible. We deal with this then at 33.2. The court in also cited Foot, and that's another Roman Dutch authority on the point, who similarly says that under Roman Dutch law, if the deceased did not impose the duty of burial on anyone, the matter would affect those who have been named in the last will as heirs. If no one has been so named, it affects the legitimate children or the blood relations, each in their order of succession. So, and then that authority is then followed in paragraph 33.3. So no one has been appointed to dispose of the human remains. Then Human versus Human then deals with us a 1975 authority. If the deceased has appointed no one to perform them, that is the funeral rites, the duty falls to the heirs nominated by the will. If no heir is nominated, the legitimate or cognate heirs who succeeded must do so. Failing this, the duty of burying the deceased falls on the civil authorities at the expense of the estate. And then again, Tsaula, which is a case that comes after Human, where it says, it is quite clear that it is the duty and therefore the right of the heir to bury the deceased and to use his discretion in doing so where no testamentary directions have been given. That's Tsaula, it's a 1976 judgment. And then a year later, Mbanjwa versus Mona, again, 1977. Then 1984, Kumalo versus Kumalo, Sekeleni, 1986, Kalaba, 1990. Then it runs all the way. Basically, the law is this. You don't contract over human remains. A corpse is dead. It's not a property. It cannot be contracted upon. What you do, you follow the law of succession. If there is a will, you follow the will. If there is no will, the law of interstate succession applies. So if you are dead and you are a husband, your remaining wife takes the decision. If the wife is also deceased or incapable of taking the decision, the children take the decision. If the children are incapable, your parents take the decision. If the parents are incapable, your siblings take the decision. But
If the wife and the children cannot agree,
yes,
and the deceased died intestate.
Yes, the wife then takes the decision because it's the heir. So the executor will generally follow the will, but the heir will then make a decision because that's the surviving spouse.
But in case of interstate succession, the wife is an interstate heir and the children.
Yes.
Also depending on the value of the estate.
Yes.
And now, the wife, you may find that it's in a case where the husband maybe, let's say, married another person.
Yes.
And has got children with other spouses. Is it also your submission that they cannot negotiate about the burial if they don't agree?
No, they obviously can negotiate and reach a consensus, but that means they have reached a consensus on what should happen.
Yes.
What is prohibited is contracting over a corpse. But obviously a family can make a decision about what to do with the corpse. But the rules of that are succession rules, either by will or intestate, but they are succession rules. Now that's what happens when between the stage of death and burial, when the corpse is just lying in a morgue. So that's the South African law. Now we come back then to this question that we are faced with here. I don't have to persuade your lordships and my lady that you were wrong. That's not my duty today. That will be dealt with at the Supreme Court of Appeal. I simply have to persuade your lordships and my lady that there is at least a reasonable prospect that this case can be decided differently. So if you were then to apply the South African law on the contract part of the case, what would have been the correct outcome? The correct outcome would have been an unqualified right on the heirs of the deceased to make a decision about what to do with the remains of Mr. Lungu. Unfortunately, the judgment does not recognize that fundamental premise of South African law, which we say we will be capable of showing the Supreme Court of Appeal that there's a long list of authorities on this point, and the long list of authorities is against the Zambian government. There's a secondary aspect to the South African part of the case. I've just been dealing with the common law, which is this: South Africa would have proceeded from its own constitution as a starting point. And Ms. Esther Lungu did in fact plead constitutional rights. We've cited two authorities. The one is the authority of Mohammed. What happens to a foreigner who's in South African soil and comes to a South African court? Because that's where Ms. Lungu is. The case of Mohammed is very, very crucial because you have a Tanzanian who is suspected of committing terrorist activities in Dar es Salaam, bombing the US embassy, flees to South Africa, gets caught in South Africa. Is he entitled to the protections of the South African Constitution? And he's not caught in South Africa, he's been sent to America. So that's the problem. He's foreign, he's bombing something there, he's here, he's wanted in America. The question came then in 2001 before the Constitutional Court. Well, is Mr. Mohammed entitled to the protections of the South African Constitution? The Constitutional Court said for as long as he is in South Africa, in our jurisdiction, he's entitled to use our Constitution to protect his rights and interests. Another case is COSA, which we've also referred to. Foreigners come to South Africa. Then they say, no, we don't have access to socio-economic entitlements or privileges under Section 27. We also want to apply for those benefits. And then the government says, no, if you are a foreigner, you are not entitled to the South African protections. Now, Justice Mohoro deals with this and then says, Section 7, subsection 1 of the Constitution applies to everyone who is in the territory of South Africa. So the only qualification to obtain our protection is being in the territory of South Africa. Now we apply that to this case. Again, I don't have to show that you were wrong, that's not my duty today, but we just apply that to this case. Ms. Lungu is in South Africa. She is suing in a South African court. She's relying on the South African Constitution for protections. That has two consequences. The first one is the right to dignity, and then the second is the right to family integrity that are provided for in the South African Bill of Rights. And she's entitled to assert those in order to assert autonomy over the body of a husband. This is her husband who's died. She says, well, I want to dispose of this body as I wish. What you cannot have a foreign state coming to our courts demanding the application of a foreign law in order to deny someone who is in our jurisdiction the rights that are protected by our Constitution. That substantially weakens the protections that are in our Constitution. So that's the second feature of applying South African law, is that inadvertently, I won't say this is deliberate, inadvertently you end up depriving someone who is in our territory of the protections of our Constitution. And those protections of our Constitution apply in relation to our state, our own state. Now, how much more in relation to a foreign state? So that's the second aspect that we say we would like this matter to go to the Supreme Court of Appeal. And then there is a judgment.
Sorry to interrupt you, Mr. Ngugaitobi. On that aspect, you agree that a person who is in South Africa can enter into an agreement with a foreign state. And I think that this is the gist of this matter. Mrs. Lungu, the judgment says that entered into an agreement with a foreign state.
Yes.
If there was no agreement at all,
Yes.
I think I follow your submission 100%. But this judgment says that they did enter into negotiations and reach an agreement.
No, I agree that the fact that you are a foreigner in South Africa does not deprive you of the right to enter into an agreement with a foreign state. But I'm saying that what is supreme in that equation is the South African Constitution.
Yes.
That you still retain your entitlements as a foreigner if you are within the Republic to rely on the South African Constitution to protect you.
I agree with you on that point.
Yes. Now, again, the problem, again, this was an issue that was disputed on the papers, right, about what is the status of FAA 7 versus FAA 9. It was disputed. But the point I'm making is that that contract must itself be consistent with South African law. You cannot enter into an agreement that is inconsistent with South African law. You have to enter into a contract that is recognized in South African law. And you can't have a foreign state that demands the application of foreign law in a South African court, because that denudes the South African Constitution of its autonomy within its territory. And Zambian law, there was nothing here that suggested that Zambian law is extraterritorial in its application. Zambian law is not extraterritorial. It applies in Zambia, not here. This point, this is now the third part, I'm going to close the discussion on the contract, is dealt with in the judgment of East Asian Consortium versus MTN. This question about Lex Loci. It's reported recently in 2025, volume 5, SA 33. And there are two judgments that are delivered. There's a judgment by Justice Unterhalter for the majority and Justice Molemela for the minority. Justice Unterhalter, between paragraphs 99 and 110, deals with the rules of resolving a Lex Loci problem. In that case, it is a delict. So what the issue in that case is that MTN is accused of bribing Iranian generals in order to secure a contract in Iran. But the litigation is in South Africa, that they must pay damages to a certain company that lost out on the bid because of the bribery. The question then that arises is which law should apply, Iranian law or South African law? And Justice Unterhalter starts with explaining what the rules of private international law are. And he says it's the court that has the closest connection to the suit. And then Justice Molemela makes this point I've been making, that those rules are themselves subject to the South African Constitution because it's supreme in relation to our territory. It's supreme. So even where you've got a Lex Loci dispute, where you say in the Lex Loci dispute, I'm going to carve out this area for Zambia, it's still subservient to the South African Constitution if the dispute is being litigated in our territory. So even then, if you applied those rules of the Lex Loci that are, and there it was Lex Loci delictu, because it was a delict case. Say Lex Loci contractu, it's a contractual case. What is the law that has the closest connection to the suit? What do you have? You have a South African, you have a person in South Africa, and a body in South Africa, and a contract in South Africa. All of those three elements. The contract is concluded here. The max, in other words, the subject of the contract, and I'm using the word max advisedly because my own submission is that a body is not a max. A dead body, a corpse is not a max. And then you have the party, one of the parties in South Africa as well, concluding that contract. Now you then have to ask yourself, what is the jurisdiction that has the closest connection to that suit? Then it becomes South Africa. And the law in South Africa is clear. There is an autonomous right on the part of the widow to decide what to do with the bones of their husband. Now, we said these things are controversial in our law. They are also emotive. But there are also unsettled legal principles. The MTN case shows us that they are unsettled. MTN is now before the Constitutional Court. Leave to appeal was applied for. But the issue has still not been settled about how to resolve a lex loci dispute in the sphere of contract. And what is the role of the Constitution in a lex loci dispute? It is not correct that the lower courts should have a final say on the matter. What is correct is that disputes like this must be finalized by the Supreme Court of Appeal. We were hoping that we could speed this thing up and get to the Constitutional Court sooner. We've been told we must start here. That's fine, we accept that. But the question of principle remains. This is a complex legal question. It has not been resolved before. It's the first case we are aware of where a foreign state comes here to claim the bones of a deceased person contrary to the wishes of the wife. It's the first case that we are aware of.
On the time allocated, I'll give you another 5 minutes.
I started at 10:53.
Okay, yeah. So I'll give you another 5 minutes to
Yes,
round up.
yes. Yes, so that's why we say this is a matter that should go to the Supreme Court of Appeal. Now,
Sorry, is your basis the lex loci contracting? Because you say it's not a contract. You can't conclude a contract on a body.
yes, that's what I say as the first basis. And then I'm saying on the alternative, if that submission is...
So it's alternative.
Yes, if that submission is incorrect, I'm asking the court to follow MTN and ECA. But you don't have to follow them. You simply have to say they show that the issue is a contentious issue, which must be resolved by the Supreme Court of Appeal. Then we come to the question of the burial rights. How is that issue to be decided? There are two problems that I want to point out. The first one is that you have this tension between the lex loci and the burial rights. Both of them could give you different outcomes. Because it's possible for you to say, if I were in Zambia, the state interest would trump the interest of the wife. But if I'm in South Africa, there is no way that the state interest would ever trump. But if I'm applying the lex loci contractus, then South African law applies, and therefore it's easy to resolve the dispute. So even that issue about what Zambian law is still comes back to the first issue of the lex loci. So the lex loci is the key to resolving the dispute, and the lex loci is a complicated question of law that it requires. Now, if that's wrong, what I have submitted to the court, if that's wrong, you still have the residual problem, which is, what is the Zambian law on this issue? And there are two related questions. Question number one is, how do you prove the law of a foreign state? And South African authorities are clear. The law of a foreign state is a question of fact, it's not a question of law. And therefore it's proven by evidence. And whether you had enough evidence here or not is a debatable question. But what's clear is that we did not have an affidavit from an expert proving what the Zambian law is. And what that law ultimately revolves around is one judgment, Kaunda. And what is notable about Kaunda is that it never resolves the question of what the law is in Zambia over the human remains. When we did our own research, what we found is that Zambia is one of these unique jurisdictions. At some point, they did follow the Roman Dutch system when they were part of the Rhodesia. And then at some point, they did follow the English system. But we looked at Blackstone, who is the main authority of the English common law. And we looked at Foote and Hugo de Groot, the main authorities in Roman Dutch. Both of them actually agree on the status of the human body, that it's outside of contract, but if it is to be contracted upon, the decision is that of the heirs. So even if Zambia's common law is the English law system, we come to the same conclusion. But Zambia also is unique because Zambia has a fundamental rights constitution. Section 1, subsection 1 says the Zambian constitution is supreme. And it contains the same protections that the South African Constitution contains: privacy, dignity, equality. And those would have been rights that Mrs. Lungu would have been entitled to enjoy, even if she was in Zambia. And then you have the third problem, which is the Kaunda decision is a unique decision and distinguishable on the fact. Kaunda died whilst the benefits were extant. Mr. Lungu died whilst the benefits had been removed. You cannot reinstate benefits on a corpse. The legal position is preserved as at the time of death. The legal position as at the time of death is that Mr. Lungu had lost his presidential benefits. So those could not be...
What about his right to be buried? Had he lost that? He had not had to have passed on.
No, he lost the benefits that came with being a president of the country.
The protection, the office staff?
Yes, all of those.
But the right to be buried and every attendant benefit that flows from passing on as a former head of state?
No, he has a right to be buried, but the corpse doesn't have any rights. The wife has a right to bury the deceased, but the wife has made that decision. The widow has made that decision. What you cannot have, and this is the oddity of the argument by the Zambian government, if the rights and benefits, because a corpse has no rights, so you cannot say a corpse has a right to be buried. A corpse has no right. A corpse is not a legal thing. So if the benefits are removed, those benefits are removed on a living thing, on a living organ. Once life ends, the rights also end. So what they have now tried to do is a very artificial thing, which is to reinstate rights on a corpse.
No, those benefits would be for the wife, not on the corpse.
Precisely.
That's why they say under oath that those benefits would
Precisely.
continue.
Those would be benefits. Yes, those would be benefits of the office that was held by Mr. Lungu, but at the moment, those would be benefits extended to the widow. Exactly. Justice Lidwaba, you are absolutely correct. Now, if it is a benefit, no one is compelled to accept the benefit. No one can be compelled to accept the benefit. It imposes no obligations on her at all.
Yes, but did the Kaunda judgment say it's just because of the benefits?
No, it did say that it's because of the status
Yes.
of the former president.
And his status remains that of a former president.
Well, yes, the problem remains that the benefits attaching to that status were removed. And one of the benefits is getting your burial paid for by the state, which confers on the wife. And that is the critical problem. And the fundamental problem, though, with Kaunda is that it does not say that this is the law in Zambia. And it never engages with the rights of a widow when the widow says, this is what I want to do with the bones of my husband. It never engages with that. And then it makes
But this judgment, the way I understand it, is not saying the Zambian government should impose the Kaunda judgment when the corpse is in Zambia.
This judgment here.
Yes.
No, I would say this judgment is even more invasive because the corpse is here. It says the corpse must be repatriated.
Based on the agreement.
Oh, yes. No, I agree. If the true ratio is the agreement, then I don't have to advance what I'm advancing because I've said enough about the agreement.
Okay, thank you.
Mr. Last question from me. I hear you say, and I understand what you say, unique set of facts should go to the SCA. But it's so fact specific. Will it ever be a ratio for another decision?
Yes, we would submit that the question as to a foreign state.
And a foreign ex-president.
Yes, it's so unique. It's really a unique case. But it cuts both ways. It's the uniqueness of the case that requires the authoritative statement of the Court of Appeal. because of the consequences that it has for our constitution.
But as I say, it's so fact-specific. Will it really be a precedent for something else?
Who knows? Who knows? We don't know, but I think that the uniqueness of these facts shows that it's actually something that Mohammed, for instance, we always thought was an extreme case. But in 2012, we had another judgment in Botswana on similar facts. And no one could have thought that the Mohammed judgment would be used again. Since the Botswana case, we haven't used Mohammed again. But there's something unsettling, Justice Kotaren. There's something unsettling about a foreign state coming to our courts and demanding that its law must be applied extraterritorially. That is a deeply disturbing precedent. And that's, we say that let the SCA resolve that problem.
Okay.
Thank you, Justices.
Thank you. Question?
May it please you, my lord, my lady. I just need to start briefly with the grounds upon which leave to appeal may be granted. And the reason is because, if I understand my learned friend correctly, the alternative ground for leave to appeal, in other words, compelling reasons, what he submits is that the merits of the matter, in other words, whether it has prospects of success, is completely irrelevant. I just need to take you to, in the heads of argument, we rely on the Ramakatsa matter, it's paragraph 6, where the SCA stated, and you find the reference there in footnote 5, that where it concerns the issue of compelling reasons for granting leave, the court said what these issues may be, and then concludes by stating, however, this court correctly added, quote, but hereto the merits remain vitally important and are often decisive. So it's not completely irrelevant. It is
in paragraph 10 of that judgment.
It is Ramakatsa in
Your paragraph 6.
my paragraph 6, paragraph 10 of the judgment, my issue. I will also start with the choice of law issue and just briefly deal with that. My learned friend indicated or submitted that there is a difficulty as far as that is concerned, and we submit that that is not the case. The lex causa in this matter, that is there are actually two. The first is the agreement itself. The second is the burial right. When we talk about the agreement, this court correctly found that South African law will apply. And I'm in absolute agreement with my learned friend that that is the correct position, because it's the lex loci contractus. I will take you to the SCA decision that says that if there is such a conflict of law rule, that rule should apply unless there are other factors that would oust it. And in this case, we submit that there are no other factors present that would lead to a different law being applied. South African law must apply. When we deal with the burial right, that's a different lex causa. And what this court found is that when you deal with the right to bury a corpse, the lex causa will be Zambian law because it has the closest connection to the issue in dispute. And we will demonstrate that that conclusion is in harmony with the recent decision of the Supreme Court of Appeal in the East Asian matter. But if I may just take a step back and deal with the lex causa. What happened here is that there was an agreement concluded between the family and the government that the right to bury, which vests in the surviving spouse and the next of kin, may be transferred to the government. That's the terms and the effect of the agreement. That agreement falls to be adjudicated in terms of South African law, and we will submit that there was nothing unconstitutional and there can be no argument that such an agreement would offend against the norms and principles of our Constitution. When we then look at the burial right and the court's categorization and then ultimately classification or finding that Zambian law would apply, we submit that you should think away the existence of a contract and then ask yourself, what would be the position if in a case such as the present one, the government of Zambia approaches this court seeking the repatriation of the body of its late president under circumstances where that president was not domiciled at the time of death in this country. He was only temporarily present here, and he was a person of national significance.
And do we know whether the family was permanently here?
On the papers, it is stated that they are temporarily in the country. So those factors should be considered to determine which law would apply, and we will submit that the court correctly applied the connecting factors, considered the connecting factors, and correctly came to the conclusion that the burial rights fall to be determined in terms of Zambian law. So my learned friend's submissions that when Foot and Groot discussed the matter of the burial of a corpse and how a corpse should be treated, it deals with the right to bury, which is what this agreement is all about, and which is what the Zambian law is all about. It is not to deal with a corpse per se. It concerns the burial right, and that's what the parties contracted about, and that's also what Zambian law is concerned with. So the reference to the matter of Muhammad and the subsequent case really do not assist in this under these circumstances. We have no difficulty that the Constitution would apply. Obviously, you must look at the agreement through that prism. You also need to consider if the Zambian law would fall foul of our Constitution and the constitutional principles. And we submit that there is no ground or case made out that it would offend against the Constitution. You will recall, Justices, that in argument, your attention was drawn to the matter of Singadi, which is a judgment by a single judge in this division.
By Mufate J, is that the judgment you're referring to?
Indeed. It is in that matter where the court also found that, yes, a spouse has a right to bury, but under circumstances where where the deceased, I quote, was a public figure of national importance and was to be accorded a civil funeral by the provincial government of the Northwest, then the wishes of the family must yield to what is in the public interest. And this judgment, I submit, cannot be argued that what was found there would offend against constitutional principles. Now, I refer to that matter just to demonstrate that even if Zambian law did not apply or should not apply.
Sorry for
there is a clear precedent in our law that under similar circumstances, private interests of the family would yield to the greater good. So, back to the choice of law, I just briefly need to refer to the East Asian matter. It is in paragraph 22, onwards of the heads of argument. My lords, my lady, you will no doubt carefully read this decision. But what the court here stated, and the majority judgment by Unterhalter J.A., was that if there is an applicable choice of law rule of general application, such as the lex loci contractus, in other words, a place where a contract is concluded normally will be applied, or, as was the case in this matter, the lex loci delicti, where the delict is committed, that law will apply. That law would apply unless it is displaced in favor of the law of the country with a manifestly closer, significant relationship to the occurrence and the parties. And what the SCA pointed out is that the Birchall decision that previously held that you need to balance the choice of law general rule with the other connecting factors and then come to a decision, the SCA said no, that's not what you should do. You should apply the law, the choice of law rule of general application, unless ousted. So if you apply this to this matter, and in the heads of argument, in the quotation in paragraph 23, we underlined the relevant portion there where the SCA stated that in cases where there is uncertainty as to the lex loci delicti, the legal system with which there is a significant relationship will decide the question of the lex causae. Now, in this case, the applicants in the application for leave to appeal appear to contend that there was a delict committed. That's obviously not the case. So what we contend or what we submit is, if you take this principle that the SCA made clear, is that when you talk about burial rights, you need to look at what law of burial rights would be a choice of law rule of general application. And if you're uncertain, you need to look at the connecting factors that may oust or that may lead to a different law to be applicable. And we say in this case, to the extent that there may be doubt as to the existence or the content of the law relating to burial rights, then you must look at the connecting factors. So it takes you to that second leg, and this court, with respect, in paragraph 26, quite correctly concluded with reference or after consideration of those connecting factors that Zambian law must apply. So we submit that as far as the choice of law issue is concerned, that no other court would reasonably conclude that a different outcome should be arrived at. And in any event, even if South African law were to apply, the conclusion would be the same. And that is that the Zambian government would have the burial right. And that is the clear right that the applicant, that the respondent relies on in the founding papers. It says, I have a right to bury. And the fact that the late president is in South Africa does not detract from that right. And that right can be enforced in this country. There's nothing sinister about the government turning to the South African courts to enforce a right that it has in terms of Zambian law, and ultimately also in terms of South African law. In the leave to appeal, The applicants raise some 16 grounds. In the heads of argument, we classed it thematically into 3 categories, or three themes. The first one is the correctness of the judgment as far as FAA 7 is concerned. The applicants contend that was never an agreement, and they say that the court erred. We say that that flies in the face of the common cause facts on the papers. On the applicant's own version, they agreed to the implementation of FAA 7. Their spokesperson, the 7th respondent, the 7th applicant now, Mr. Zulu, confirmed the agreement. He called it a compromise agreement, and it is that agreement that the court found existed, and it correctly applied the canons of contractual interpretation. The reference is there to Indumeni. And we submit that no court would reasonably conclude otherwise. The second theme, the conflict of law issue, I dealt with. And the third is that the court erred in that when it granted Pref 4, it granted an order for the repatriation, whereas what they said is that in the notice of motion, declaratory relief was sought. And the answer to that criticism is simply the following. The Constitutional Court stated, and the reference is in paragraph 30 of the heads, I quote, an appeal can only succeed if it is shown that the order issued was not supported by the facts on the record and the application of the relevant law to them. And what we say is that the relief in prayer 4 mirrors what is granted in prayer 5. So prayer 4 simply says that the government is ordered, I just need to get to that prayer. It is ordered that the applicant is entitled to repatriate the body of the late president for a state funeral and a burial thereafter. And then 5 mirrors that. The 8th respondent is authorized and ordered upon service of the court order by the sheriff to immediately surrender the body of the late president to a representative for repatriation for the purposes in 4. So, under circumstances where prayer 5 is clearly and demonstrably not at odds with the facts and the law, prayer 4, that simply mirrors that, also cannot could not have been incompetent, and the court could have granted it. What we say in conclusion is that the application for leave to appeal has no prospects of success, neither in terms of 17(1)(a), Roman 1, or in terms of Roman numeral 2. And the reason why we submit that there are no grounds for concluding that there would be an important question of law, or that the test in terms of Roman sub 2 is met, is because of the uncertainty. What is this discrete issue of public importance that will have an effect on future disputes? What is that issue? Justice Pottrell, you asked that question. How would such a dispute that is in the present case so fact specific again arise in future? How would another court reasonably conclude that that may be the case? What would be the dispute that may arise? I submit that the applicants can't answer this question. So on the second leg of the leave to appeal, we submit that there is also no grounds. This application falls to be dismissed with costs, scale C, inclusive of 2 counsel. Apart from that, we abide by what's in the heads of argument, justices.
Thank you, Christian.
Let me start with where my learned friend started. So my learned friend's premise is the following. One, he accepts that the agreement is to be interpreted or applied according to South African law. But then he says that because what he calls the lex causa is Zambian, therefore the right to bury is Zambian. And then he says that the agreement is not about the corpse, it is about the right to bury. Now that's the basic premise of his argument. On the first argument about the distinction between the lex loci contractu and the lex causa, it's actually not recognized anywhere in the law. If the court looks at paragraph 99 to 101 of 111 rather of the MTN judgment, the word lex causa simply refers to the cause of action, nothing else. What determines which law applies is lex loci. And so it then takes over the entire dispute. And it's obvious why that is so. If you followed my learned friend, you would end up with conflicting outcomes because you will always split out lex causa from lex loci. That's just illogical. So once we've decided the lex loci, then everything that falls under that is then to be decided in accordance with the law of the lex loci. So if my learned friend concedes that the lex loci is South African law, then the dispute is to be decided according to South African law. Zambian law becomes irrelevant. So he has in fact proven the very problem that we've been trying to say in a very inarticulate way. So if he concedes that the lex loci is South African law, the question then is, was South African law correctly applied in denying Ms. Lungu the right to bury the husband? That then has enormous implications for future disputes. Enormous implications about wives unable to make a decision over the body of their husbands. On a supposed public interest, see what they've now started doing? They've now also started referring to the Senyati case, to say even there the public interest was held to override the wishes of the spouse. So we are now right at the commencement of a dangerous road towards the deprivation of the rights of widows to take care of the bones of their spouses. So South African law could never countenance this outcome that we have here. South African law has been clear on the common law perspective and on the constitutional law, that the right of the spouse is basically unqualified. She decides what to do. If she's dead, the children decide what to do, but it's the family that decides. A lot of the cases have tended to be intra-family, like the Sengati case, have tended to be intra-family. But once it's inter-family, it's family versus others. The family trumps. That's the core of the South African law. And then the second aspect, which my learned friend just doesn't address at all, he addresses it by avoidance, is the question of the validity and enforceability of a contract over a dead body. Foot and Grotius are so clear on this. There's no enforceable South African contract over human remains. And those articles we've referred to are clear on the point. Again, if my learned friend is right, we also create new law in which we turn against the common law and we say, from now on, you can contract over human remains. And you can contract against the wishes of the family over human remains. That, again, is not part and parcel of South African law. So, again, those two mistakes that my learned friend has made in his argument simply show why the dispute ought to be decided by the Supreme Court of Appeal. On the lex loci, he is dead in the water because South African law applies. Number two, on South African principles, there is an unqualified right of the spouse. And number three, on South African principles, there is a proscription, a prohibition on contracting over human remains. Then the dispute becomes a narrower dispute than the one we outlined, but it becomes an incredibly important dispute because it sets out binding precedent for the future. My learned friend also says he cannot see what this important issue of law that will live beyond this judgment. He may not see it, but we see it. The important issue of law is the contest between the rights of a state as well as the rights of the family to decide on the burial. He himself has pointed out to a case in South Africa where this issue arose. A provincial government decides to take over the body of a deceased husband and says, I'm going to bury this body. The spouse says, I don't want to. I want to bury this body according to what I want and what he wanted before he died. According to him, the wishes of that spouse must be overridden by the wishes of the government. This is so foundational to the right to bodily integrity and autonomy in South Africa that it simply can never be the South African legal precedent. So I'm afraid if he did not see the important point of law, he has himself inevitably articulated the problem that we say deserves the attention of the Supreme Court of Appeal.
Sorry, can I ask you, what does this judgment, what is the binding principle of this judgment?
Well, there are two as we understand it. The first principle is that the interests of a spouse can be overridden by
A foreign government.
by a government. In this case, it happens to be a foreign government, but by a government. Now, that we say is a fundamental problem. The second one is that a contract, my learned friend characterizes differently, over a dead body or over a corpse, is a recognized species of contract in South African law. Now, those two principles, outside of the issue of prospects of success, those two issues are legal principles that will forever be relied upon. And you know, one of the reasons, Justice Libraga, is that they will say this was a full court decision and it has an elevated status for future disputes. And they can ignore Justice Mokgwatleng's judgment as a single judge who decided a fact-specific case. But they can't ignore this judgment because this is a judgment given by 3 judges of the Pretoria High Court. And so those principles will remain with us, whatever happens. And that's why we ask that you kindly refer the matter for determination in the Supreme Court of Appeal. Thank you, Justices.
Costs?
Well, if I win, there are no costs because there will be costs in the appeal.
Yes. And if you lose?
Well, this is a private dispute. So I think I got costs against me anyway in the... I didn't. Oh, no, then I should not get costs. You know, you should always have a junior. Then there should be no costs, regardless of the outcome.
Thank you.
Perhaps in your paper earlier on, I alluded to the following, that the extra articles that you handed up should be given on the case lines to the credit of your instructing lawyers and junior. These articles are there on case lines.
Oh, thank you. Again, it's my own ignorance. It's so clear who's running the case.
So one counsel cost.
Yes. I think my junior's cost.
Unless you need them for other references, I have them online.
Yes, I probably should. I don't know, maybe as Justice Potter says, I'll never get a burial dispute again. let it take them. I have nothing else to say.
Thank you very much. Judgment is reserved for the judge.